Hello, this is Jason Shoup, founder and managing member of the Centers for Better Insurance. Today we're going to take a couple of minutes to look at where we are on COVID-19 business interruption litigation. Across the United States, as of October 22, I count 22 business interruption rulings. 18 of those have taken place in federal court, 4 in state court. Let's dig into the federal court cases first. 6 in California, 3 in Florida, 2 in Missouri, 2 in Texas, 1 each in Alabama, Georgia, Illinois, Michigan, and Minnesota. So quite a geographic spread. Over on the state court side, we see 1 each in DC, Michigan, New Jersey, and North Carolina. As to the substance of these rulings, 17 of the 22 rulings resulted in a dismissal of the policyholders' claims based on the pleadings. Now that's significant. What that means is the court took all of the allegations in the policyholder's complaint as true, looked at the policy wording, and said even if the policyholder's allegations are true, it doesn't trigger business income coverage. Now, many of the 17 have also included leave to amend, so the policyholder is able to go back, file an amended complaint, and that amended complaint may or may not be successful in overcoming subsequent motions to dismiss. So the 17 cases are not necessarily dead at the trial court level, but may continue on through amended pleadings. Beyond the 17, we have 5 cases that have resulted in rulings favorable to policyholders. In 4 of those cases, the policyholder is permitted to move forward into discovery, the fact-finding stage of litigation. And 1 decision, the most recent to come to light in North Carolina, actually ruled finally on the merits for the policyholder. I put these rulings into 3 categories based on the policy wording and the nature of the allegations in the complaint. The first category are those claims made against policies with a virus exclusion. 14 out of the 15 claims against a policy with a virus exclusion have been dismissed on the pleadings. The only one which has survived is in a Florida federal court. The second category are claims where the policyholder has not alleged COVID-19 causes property damage. That has been successful in only 3 out of 18 cases. Now, importantly, there's an overlap with those decisions with policies containing a virus exclusion. So what we know is that only 2 of the 3 surviving cases that did not allege property damage did not have a virus exclusion, and those are in New Jersey State Court and in North Carolina State Court. The third category are cases where the policyholder alleges COVID-19 did cause property damage, and we have 2 surviving cases there, neither of which had a virus exclusion, and those exist in the same Missouri federal court. So in short, 3 types of cases: virus exclusions, highly likely to result in dismissal. Then as we kind of peel underneath that, we see a divergence between cases alleging that COVID-19 causes property damage and those that allege COVID-19 does not cause property damage. Let's dig into this. Let's start with the 1 case that has survived a motion to dismiss, even though the underlying policy had a virus exclusion. Importantly, this took place in a federal court in Florida. 2 other federal courts in Florida have dismissed COVID-19 business interruption claims. This court has allowed the complaint to proceed through to the fact-finding or discovery stage because it was uncomfortable with the terms of the specific virus exclusion. Let's dig into that. So many virus exclusions reference loss caused by a virus that induces or is capable of inducing physical distress, illness, or disease. In this particular case, The wording of the exclusion referenced loss caused by the presence, growth, proliferation, spread, or any activity of a virus. Given the reference to virus in connection with fungus, wet rot, dry rot, the court wanted to at least move to the next stage to undertake some fact finding to understand better the nature of this exclusion. The second category of cases are those in which the policyholder does not allege COVID-19 causes property damage. We have two cases here that have survived a motion to dismiss, both in state court, one in North Carolina and the other in New Jersey. In general, the policyholder's argument is that a government lockdown order, whether from a state or local authority, mandated the closure of the policyholder's business. Second, this loss of functionality alone constitutes a direct physical loss of the insured property, triggering coverage under the policy. The insurance companies argue that direct physical loss requires some type of a material alteration or physical damage to the property in order to trigger coverage. Now, in the case of the New Jersey decision, the court reviewed both of these arguments, didn't decide on the merits, but instead said it was worthy of continuing the case for the purposes of fact-finding through discovery. The North Carolina case took a very different turn. The North Carolina State Court found as a matter of law that direct physical loss includes the inability of the policyholder to utilize or possess something in the real, material, or bodily world, including the loss of the full range of rights and advantages of using or accessing the policyholder's property. Specifically, the plaintiffs here were expressly forbidden by government decree from accessing and putting their property to use for income generating purposes for which the property was insured. In short, the court decided the case finally on the merits in favor of the policyholder, reading the allegations of the complaint and the policy itself. This is probably the most significant decision that we have seen to date favoring policyholders. The third and final category are those complaints in which the policyholder has alleged COVID-19 causes actual physical damage at the insured property. And we have two of these cases that have survived motions to dismiss, both before the same judge in a Missouri federal court. The policyholders generally allege that COVID-19 physically attaches to property, making it unsafe and unusable, therefore leading to a shutdown of the business. The insurance companies generally respond that a physical alteration or damage to the property is necessary and that the allegations in the complaint are insufficient. At this stage, in these two complaints, the court decided that there was adequate grounds to allow the case to proceed into discovery. Now, ultimately, the challenge for the policyholders will be actually proving that COVID-19 has physically attached to the property, and that's why the business was shut down. We remain very early in the COVID-19 business interruption litigation experience. Indeed, we only have 22 rulings out of more than 1,000 pending cases. At this stage, we can draw a few high-level observations. First, virus exclusions appear to be holding well but some wordings work better than others. Second, federal courts appear quite strict in requiring some sort of allegation of physical alteration to property before business interruption coverage can be triggered. But state courts are accepting, in some instances, merely claims of loss of use. Third, an allegation that COVID-19 causes physical damage appears sufficient to survive a motion to dismiss, but may prove a challenge to policyholders during the discovery phase. You can learn more about COVID-19 and business interruption coverage at www.betterins.org. On behalf of the Centers for Better Insurance, thank you for spending this time with us today.